The courtroom was packed that morning. Every seat was taken. People stood along the back wall, pressed against each other, quiet and tense. Outside, news vans lined the street. Camera crews set up on the steps. Reporters adjusted their earpieces and spoke in low voices. It was the kind of day that a city holds its breath for. Inside, the air smelled like old wood and coffee. The lights above were bright and unflattering. They made everyone look tired, even the attorneys who had probably slept well. The American flag stood at the front of the room, perfectly still. The court clerk sat at her desk, shuffling papers. A bailiff stood near the side door with his hands clasped behind his back, his face blank. Marcus Aldridge sat at the defendant's table. He was 43 years old, with short dark hair and broad shoulders. He wore a gray suit that fit him well. His tie was dark blue. He looked like a man who had been to many important meetings in his life, and this was just one more. His hands rested flat on the table in front of him. His eyes moved slowly around the room, taking in the faces, the cameras near the back, the judge's empty chair. There was no fear in his expression. That was what people noticed most. Everyone in that courtroom was nervous except him. His attorney, a tall woman named Claire Forsyth, leaned toward him and said something quietly. He nodded once. He did not look worried. He did not look relieved. He looked like a man who already knew how the day was going to end. The charges against Marcus Aldridge were serious. Racketeering. Money laundering. Conspiracy to distribute narcotics across 3 states. The prosecution had spent 14 months building the case. They had wiretaps. They had bank records. They had 2 confidential informants who had testified under oath. They had photographs. They had phone records. The evidence was stacked so high that even Aldridge's most loyal supporters had stopped coming to court 3 weeks into the trial. The prosecutor, a man named Daniel Cruz, was young for the position, just 38, but he had the kind of confidence that older men sometimes spent decades trying to find. He had laid out the case clearly, methodically, piece by piece. The jury had listened carefully. They had asked good questions. The deliberation had taken 2 days, which the media described as surprisingly short for a case of this size. Judge Patricia Weston entered the courtroom at 9 o'clock sharp. She was 61 years old, with silver hair and small round glasses. She had been on the federal bench for 22 years. She was known for 2 things, her patience and her fairness. She never rushed. She never played to the crowd. She treated every person who stood before her with the same level of attention, whether they were a first-time shoplifter or a career criminal. She sat down, adjusted her glasses, and looked out at the room. "All rise," the bailiff said, and the room rose together. Judge Weston set her papers down and looked toward the jury box. The 12 jurors filed in one at a time. They did not look at Marcus Aldridge. In trials, that is often the first sign. When a jury does not look at the defendant as they enter the room, it usually means the verdict is not in the defendant's favor. Every attorney in that building knew this. Claire Forsyth knew it too. She wrote something on her notepad and did not look up. The jury foreman was a retired school principal named Gerald Marsh. He was 67, with a calm, steady manner. Judge Weston asked him if the jury had reached a verdict. He said they had. She asked him to read it. Gerald Marsh unfolded a single sheet of paper. The room went completely silent. Even the reporters at the back stopped whispering. "On the charge of racketeering," he said, "we the jury find the defendant, Marcus Aldridge, guilty." A sound moved through the courtroom. Not loud. More like a collective exhale, a release of pressure that had been building for months. "On the charge of money laundering, we find the defendant guilty. On the charge of conspiracy to distribute controlled substances across state lines, we find the defendant guilty." Marcus Aldridge did not move. He did not close his eyes. He did not put his head down. He simply sat there, hands still flat on the table, and listened to each word. When the foreman finished, Aldridge turned slightly and looked at Claire Forsyth. She put her hand on his arm. He gave her a small nod, the kind of nod you give someone when you are telling them that everything is fine, that they should not worry. Judge Weston thanked the jury. She set a sentencing date 4 weeks out. But that afternoon, After the courtroom had cleared and the media had gone live with their reports and the city had begun to process what it had just witnessed, she decided to hold an emergency sentencing. The prosecution had requested it, citing concerns about flight risk. The defense did not object. By 3 o'clock that afternoon, Marcus Aldridge stood before Judge Weston again. "Mr. Aldridge," she said, her voice calm and even, "the crimes of which you have been convicted are serious and far-reaching. They caused harm to individuals, to families, and to communities. The court has reviewed the evidence in full. It has listened to both sides. And it is the judgment of this court that you be sentenced to 27 years in federal prison, without the possibility of early release for the first 15 years. She looked at him directly when she said it. He looked back at her. He nodded once, the same quiet nod he had given his attorney. And then, for just a moment, a small smile crossed his face. It was gone almost before it appeared. But Judge Weston saw it. Several reporters saw it too, and they would write about it later, describing it as strange, unsettling, or difficult to explain. No one in the courtroom could explain it then. They would understand it 72 hours later. At 6:30 that same evening, 2 men in dark suits arrived at the federal courthouse. They did not go through the main entrance. They entered through a side door that required a key card and a security code. They carried sealed documents from the Department of Justice. They asked to speak with the chief judge immediately. The request was granted without delay. What those documents contained had been locked away for 11 years. The information inside them was known to fewer than a dozen people in the entire country, and most of those people worked in a building in Washington that most citizens would never visit. Marcus Aldridge was not a criminal. He was a federal informant. He had been working directly with the FBI since he was 32 years old. His entire life as a criminal, the trafficking connections, the money laundering, the racketeering network that stretched across 3 states, had been built piece by piece with the full knowledge and guidance of federal handlers. It was a cover identity so complete, so carefully constructed, that it had fooled prosecutors, defense attorneys, a jury of 12 citizens, and a federal judge with 22 years of experience. The operation had a name, though it would never be made public. It had been designed to infiltrate one of the most protected narcotics distribution networks in the country, a network that had been operating for over 2 decades and had survived every previous attempt to dismantle it. Traditional investigations had failed. Undercover agents had been identified and removed. Informants had been found out. The network was careful, patient, and deeply connected. Marcus Aldridge had gone inside it. Not for weeks. Not for months. For 11 years. He had built relationships slowly, earned trust carefully, and over time had risen to a position where he could see everything. He knew the names. He knew the suppliers. He knew the routes. He knew the safe houses, the bank accounts, the front businesses, and the decision-makers at every level of the operation. Because of his work, 47 individuals connected to the network had been prosecuted and convicted over the previous 3 years. 3 major distribution hubs had been shut down. Financial accounts holding tens of millions of dollars had been seized. The network, which had operated without serious interruption for more than 20 years, had been broken. But somewhere in the machinery of justice, something had gone wrong. The prosecution team that brought charges against Aldridge had been assembled without full access to the classified file that protected his identity. Some of them had been kept out of the intelligence loop entirely. Others had been told only part of the story. The compartmentalization that made the operation secure had, in the end, turned against the very men the government was supposed to protect. When Judge Weston was briefed privately that evening, in a conference room on the 4th floor of the courthouse, she was silent for a long moment after the agents finished speaking. Then she asked one question. "Who authorized this?" The agents exchanged a look. They said they were not in a position to answer that. She removed her glasses, set them on the table, and looked at the ceiling. Everyone in the room waited. "I sentenced a man to 27 years this afternoon," she said quietly. "A man who was doing his job. Who was working for the same government that just walked into my courthouse with sealed documents telling me I made a mistake." She paused. "I want every piece of paper related to this case on my desk before 8 o'clock tomorrow morning." By the following morning, the motion to vacate the conviction had been filed. It was classified. The public docket showed only a brief notation: conviction vacated, sealed order. No explanation. No press release. No names. Marcus Aldridge was released quietly through a side exit. There were no cameras. There were no reporters waiting. A car with tinted windows was parked at the curb. He got in. The car drove away. No one who watched it leave knew where it was going. But the story did not stay quiet for long. A court reporter noticed the docket entry 2 days later and posted about it online. Within hours, journalists were calling the courthouse, the Department of Justice, and the FBI. None of them received answers. The silence, of course, only made the story louder. Within a week, it was national news. Not because anyone had confirmed the details, but because the pieces were visible enough that several experienced journalists were able to construct a picture that was close to the truth. A man convicted on serious federal charges. A sentence handed down by a respected judge. A conviction vacated 3 days later with no public explanation. An informant. An operation. A system that had prosecuted one of its own. Congressional hearings were called. 2 separate committees requested documentation from the Justice Department and the FBI. Neither received everything they asked for. What they did receive was heavily redacted, pages and pages of black ink where the important words used to be. Judge Weston issued a public statement, which was unusual for her. She had never spoken publicly about a case before. But this, she felt, was different. Every person who appears before this court, she wrote, deserves to know that the process by which they are judged is honest, complete, and free from hidden interference. What occurred in this case was a failure of that standard. It was not a failure of the court. It was a failure of the systems that are supposed to support it. I am committed to ensuring that nothing like this happens in a courtroom under my authority again. The FBI issued a statement of its own. It defended the operation without confirming its details. It said that the work carried out over the relevant period had resulted in significant reductions in narcotics trafficking activity and had led to the successful prosecution of dozens of individuals involved in serious organized crime. It expressed regret for any procedural breakdowns and said it was conducting an internal review. The internal review was never made public. Legal scholars wrote about the case for years afterward. Law schools added it to their curriculums. It raised questions that did not have simple answers. How much secrecy is acceptable in a system built on transparency? Who is responsible when the government's left hand does not know what its right hand is doing? Can a trial be considered fair if the judge, the jury, and even the defense attorney are all working without the full truth? There were no clean answers. There rarely are, in cases like this. What was known, and what remained consistent across every account, was the image of Marcus Aldridge sitting in that courtroom on a Tuesday morning, hands flat on the table, listening to the verdict being read against him, knowing the full truth of who he was and what he had done, and saying nothing. Smiling that small, brief smile. He had spent 11 years becoming someone else so that the truth could come out about everyone around him. He had done it without credit, without recognition, without the ability to tell anyone in his life who he really was. He had sat in that courtroom and let them convict him, because the operation required it, because the file had not yet been cleared, because the timing was not right. He trusted that the system would correct itself. And eventually, it did. Not perfectly. Not in time to prevent the sentence. Not without damage to the court's reputation or the public's trust. But it corrected itself. Somewhere, under a different name, Marcus Aldridge was living a quiet life. He had earned that much. Whatever the failures of the system around him, his own part in the story was clean. He had done exactly what he promised to do, for longer than most people could imagine doing it, and he had done it well. The courtroom on the day of his conviction had been full of people who thought they understood what was happening. None of them did. The judge did not. The jury did not. The prosecutor did not. The reporters did not. Even his own attorney did not. Only one person in that room knew the whole truth, and he sat quietly with it, hands on the table, waiting for the world to catch up.